my favorite topic, and that is attorney's fees. And the name of the topic is, what are the troubling issues concerning attorney's fees in homeowner association matters? Okay, like a lot of other things in this field, it starts off very simply and very direct. Look at Civil Code Section 1354C. Very simply, it says, in an action to enforce the governing documents, the prevailing party shall be awarded a reasonable attorney's fees and costs. Simple and direct. So if you win, if your client, the property owner, wins, you recover reasonable attorney's fees against the association. The association has to pay reasonable attorney's fees. If the association wins, they, of course, recover their attorney's fees from the property owner. One of the problems you have is that your clients, the property owners, always think they're always going to win their case. So you have to explain to them right at the get-go that, number one, they may not win their case, and number two, if they lose, there's this double whammy penalty. But they not only have to pay your fees, they've got to pay the association's attorney's fees. So you've got to make sure that that's clear in the beginning. Now, there are certain situations where the attorney's fee statute doesn't apply because it's limited to an action to enforce the governing documents. So if you're not enforcing the governing documents, it doesn't apply. Also, there's a couple cases that have come down that say that a former member of an association cannot sue to enforce the CC&Rs. In fact, I had a case about 2 years ago where a current owner of the association sued my client, who was also an owner of the association, over the landscaping interfering with his view. And then during the lawsuit, the plaintiff moved out of the association. And I was able to get that case dismissed because he no longer had standing to bring the action because he was no longer an owner of the association, couldn't enforce the CC&Rs. So that's another limitation. Now, in addition to the attorney's fees recoverable by statute, usually the CC&Rs has an attorney's provision. And sometimes the CC&Rs has an attorney's provision that says if there's any dispute, the association recovers attorney's fees because it's written by the association's attorney. So just one way. But as you know, under Civil Code Section 1717, those clauses are reciprocal. So what it really means is whoever the prevailing party is recovers attorney's fees. Okay, now let me get into some of the complicated areas. The CC&Rs may contain a surprise called a reimbursement assessment. A reimbursement assessment is a clause in the CC&Rs that says that if a property owner or his guest or tenant causes the association to incur any expense, the association can recover that expense from the property owner. So usually I think it was primarily intended for the situation where a property owner drives his car into the wall of the association or into the fence of the association or the gate, causes some damage, and it authorizes the association to go after the property owner to recover this damage. And it would also apply to the property owner's tenant or guest. So that's a legitimate use of the reimbursement assessment. However, what I've encountered, and sometimes reimbursement assessments are actually written in this language, sometimes they're not, but what I've encountered is a situation where an association seeks to use a reimbursement assessment to recover attorney's fees when there's no litigation. In other words, you have a situation where your client's unhappy about something the association's doing, so you write a letter to the association attorney writes a letter back. You talk about maybe having a meeting to discuss it, and you have a meeting, and it goes back and forth, and then eventually something happens. Either someone doesn't, maybe your client decides they don't want to pursue it anymore. So your client says, well, I don't want to pursue this anymore, so let's just forget about it. So you forget about it, and that's it. But what happens is the association then sends your client a bill for the association's attorney's fees under this reimbursement assessment provision of the CC&Rs. And you read that section. It's written broadly, usually. Sometimes it's written to specifically say it includes attorney's fees. Sometimes it's written to say it includes all expenses of the association without any mention of attorney's fees. So there's an interesting question as to whether the reimbursement assessment can apply to attorney's fees, because normally you only recover attorney's fees when you have a prevailing party in litigation. I've got a case pending in San Diego Superior Court where I had exactly that situation. It was a dispute over an encroachment onto common area, and the association and my client were going back and forth trying to resolve this matter, and they couldn't resolve it. So the association, prior to litigation, enacted a reimbursement assessment against my client. Almost all of the reimbursement assessment was attorney's fees. So the association was going to impose a lien against my client's property. So I went into court in San Diego and got a temporary restraining order, preliminary injunction, to prevent that lien from being placed on the property and enjoin the association from imposing a reimbursement assessment based on the fact that there's been no prevailing party determination. So my client may ultimately win the lawsuit. Why should my client have to pay attorney's fees for the preliminary stages that preceded the lawsuit? So a judge agreed with me and granted the preliminary injunction, and that's in place and will stay in place until the litigation is resolved, and then we'll know who the prevailing party is. And if my client is not if my client's a losing party, then my client will have to pay the attorney's fees. If not, then my client recovers attorney's fees. But the reimbursement assessment is something, it's kind of a tricky thing, and you have to kind of pay attention to it. There's another issue that arises in litigation over assessments arising from litigation. And this is what I would call kind of a catch-22. Let's assume your client is the property owner. You sue the association and you win your case. You get $1 million judgment. Now, I don't care whether that $1 million is attorney's fees or compensatory damages or punitive damages or what it is, but you get $1 million judgment against the association. Okay? The association doesn't have $1 million, but they have to pay the judgment. Let's say they don't appeal, and we'll make the facts simple that way. The association, so you have a final judgment against the association for $1 million. The association doesn't have the money. So what does the association do? And let's say there's no insurance or the insurance company denied coverage. What does the association do? Well, they impose a special assessment against everybody in the association to pay this judgment. So let's say you've got a $1 million judgment. Let's say you have 100 homes, because I want to make the math easy because I'm not very good at math. So that results in a $10,000 special assessment against each owner. Now, as you might imagine, nobody's particularly happy about getting a $10,000 assessment. But the one who's most unhappy is your client, because your client says, wait a minute, I won this case. Why am I being assessed for the $10,000 in attorney's fees? I already paid you attorney's fees, and why am I being assessed for this $10,000? Well, there's no published decision on this issue as to whether the association can impose the assessment against the prevailing plaintiff property owner. But I had a case in Orange County Superior Court, and I was able to convince the judge that that assessment should not be imposed against my client because he was the prevailing party plaintiff. He shouldn't be penalized by having this assessment against him. So I won that case. However, I could easily see a judge deciding the case differently, and the next case I have might be decided differently. So that's something that you need to kind of take into consideration. So that is the issue of attorney's fees.